May I introduce Arun Mohan, advocate of the Madras High Court, practicing in the intellectual property field, who is going to take us through the amendments, some of the rationale for the amendments, and also with regard to assignments. And very interesting point here that whether in the urge to balance the various interests, whether too much or too little has been done. One example can be assignment of royalty, because if you see the section, it actually restricts securitization of royalty, because it says you can only assign to certain people and doesn't say to a financial institution. So interesting to hear you, Arun. Thank you.
Thank you. Good afternoon, everyone. Thank you, Shamnath and the NUJS team for having me. My take on the copyright amendment, I hope, is going to be a very practical one. The amendment to me appeared to be like any good senior counsel arguing before a court. It had as much to do with the personality of the lawyer as with the merits of the case. And the case by itself, by the way, is very colorful. Why? I am very proud of the Indian film industry. It's the largest in the world now. We have, in 2012, witnessed the 100 crore box office club to which all of us aspire. I don't know, is it coincidence that once movies started hitting the 100 crore box office, that amendments were sought? The business is booming. We have Fox and Warner Brothers, everyone investing in the Indian film industry. We have Snoop Dogg dressed as a Sardar. Very colorful. We have songs such as Kolaveri, which itself drive crowds to theatre. It's probably the de facto mechanism to promote a film. Music is no longer just something which sort of is a filler for someone to go have a quick smoke. It is what essentially creates the hype for a movie. Chamak Chalo got as much... It was probably a reason why I went to go see Ravan, and which I live to regret. So what has been the reaction of the amendment bill? Artists have been exceptionally vociferous. It's been like, it's like dowry, it's like bonded labor, and we were suffering before, and now we are absolutely free and everyone's happy. The labels have been supportive, politically correct. The radio stations have been very, very politically correct, because I'm sure even they are now treading dangerous waters and waiting to see what happens, so best not to shoot them out. And producers, they have been whining, to put it abruptly. They have been saying that the costing has not been considered, how the industry works has not been considered, and it has completely skewed up the finances of existing projects. So you can see a very sort of disparate reaction to the copyright amendment, which was supposed to balance interests. I think that sort of suggests how good of a balancing exercise this was, because if this truly did balance all interests, we would have seen some cohesiveness in the reaction, which is obviously not present. Now, about this discord in copyright law, when you look at it historically, I won't take more than 30 seconds in describing it, is that when you go back to the Statute of Anne, it was a fight between the stationers and the authors, and that's what led to what is the mother of copyright law today being passed. And ever since then, the consumers and the creators of works have always fought with who are the disseminators of the work. And very, very often there has always been a perception that it is the disseminator of the work who gains the most out of a creative work. And very often thanks to the introduction of complex provisos which we are seeing today, and international treaties to add to the whole, if I may say, mess, there is a perception that the theological purpose of copyright law, that is, you advance creative knowledge and you advance the learning of art, has just been lost in a big legislative exercise. Reasons for the amendment, very simple. This is how the authors say the producers talk to them. I'll give you an offer you can't refuse. This is very basically put to me when I had spent a few hours on YouTube seeing the videos of Mr. Akhtar and Mr. Tharoor talking, this is what appears to me. This is what the artists say. They say that producers come up to them and they don't give them an option. They force them to sign an assignment which is the only option available to them. So, and they say that this pervades every type of artist. You start from A.R. Rahman and you come down to the smallest artists, and this is the kind of offers they have to suffer. But what remains interesting is that what was the earlier statutory provision is what remains the equivalent statutory provision in the United Kingdom and America. But as per the various proponents of this amendment, they say the experience is different. And there has been no consideration of this. Why has the experience of the Indian film industry compared to the British or the American film industry been different when the statutory provision of these industries have more or less been common? And even more strangely, when we are looking at the speeches very vociferously, Elton John, John Lennon, and many of the Johns and all the names were thrown forth. They refer to foreign artists, but they never refer to these foreign provisions. They never ever consider why there should be a significant departure in Indian statutory law when there is no such departure that is reflective in international jurisdictions, from which this very same artists whom they rely on to show the system of royalties and so forth have prospered. So what was left out when we considered, when the Copyright Amendment was being considered, was that foreign law provisions were not considered at all, and that's exceptionally peculiar. The film industry practice abroad was not considered. Also, what was not considered was, why is the IFI alone demanding this provision when the rest of the world hasn't? Are the artists of the IFI so weak? It doesn't appear to me, because I'm sure the monopoly of producers is far stronger, say, in Hollywood than it ever would be in Bollywood. And also, what I found rather disturbing was an almost blanket rejection of all criticism. It was all Mr. Tharoor in his speech very eloquently compared any person criticizing these amendments to a camel in the tent, saying that, they put in their nose in the manner of a criticism, and then they come in and they'll just ensure that no rights of artists are considered at all. Now let us look at what is the effect of the amendment vis-a-vis film music, because that is the focus of my talk today. There are two very clear effects. Now the effect of this is reflected in section 18 primarily, and section 19 deals with the mode of effecting that. The effect is that an artist cannot assign his shares of royalty in a musical work, and this is very clear. It's non-assignable, it's not waivable, and an artist is entitled to royalty on every use of music except for a theatrical screening for the public. Now this, before I go on to my next slide, just to give you a brief background, film music would have primarily two kinds of use. First is a synchronization right. A synchronization right is the right to use the music along with the film, and a performance right is a right to use the music per se. Now, what this, by the second right that has been granted, artists are entitled royalty on every use of music except for theatrical screening for the public. There is and a distinction was attempted to be made by the standing committee between the synchronization right and the performance right. Now, my problem with this is that the synchronization right itself has not been granted in total. Though when we look at the standing committee recommendations, they say that the synchronization right should vest with the producers and the performance right should vest with the authors of the work. Well and good, if that is a recommendation, there is no explanation why the synchronization right has not been granted in total. The only synchronization right that has been granted to producers is for a theatrical screening for the public. Therefore, even when they hold their private screenings ahead of the release of the movie, they would have to pay the composers for it. If they didn't, it would be illegal. Any private screening. There's ambiguity as to other scenarios when the film music is used in DVDs, Blu-rays, when it's used in a television broadcast. Now, when it's used in a television broadcast, very interesting. The effect of this, I've already had a couple of opinions come into me. Ekta Tiger has been sold for 75 crores, and that's been the largest recorded sale of satellite rights for a movie. If a composer is entitled to a stake in that, that would quite possibly make him the highest paid music composer in Asia. But that's not been considered. The costing, the practicalities of working, the amendment has not been considered at all by the standing committee, and the reason for such limited synchronization rights have not been discussed. Now, what is the international experience? Let's be very clear. Lawyers, creative lawyering can pretty much do away with any amendment. The spirit and purpose can always be played around with, and that's always been the complaint of artists across the world. Across the world, there are three types of rights: that's performing, mechanical, and synchronization. Mechanical is the right to reproduce it onto VCDs and DVDs and so forth. Now, synchronization royalties are not a standard in America. And in fact, in America, there is a proposal for a uni-license by which a single license is given to avoid confusion between various societies and so forth. And rights are primarily negotiated. It's a free market. Even though the industry standards is a royalty, it is very much possible that you could get a blanket assignment if you're so willing to pay up a fee. Now, this brings me to the elephant in the room. For some odd reason, the standing committee has not considered that ownership of a copyright is not always equivalent to the enjoyment of a copyright. When I look at the amendment to Section 30, it is what is the restrictions put in Section 18 dealing with assignment are not reflected at all. Section 30 remains as blanket as ever. Now you're going to come up with me and say that now 30A says that the provisions of Section 19 would have to be followed. But let's be very clear, Section 19 builds upon Section 18. What are the restrictions for Section 18 deals with assignment, Section 19 deals with the mode of assignment. Now, what are the restrictions in the primary assignment clause is what can be found in the clause dealing with the mode of assignment. Similarly, in a license agreement, what can be licensed and what is in the mode. Therefore, Section 30, which deals with mode of license, would follow what is in the provisions of Section 30. Section 30A, which deals with the mode of licensing, would follow the provisions of Section 30. Section 30 does not impose any restrictions, which means that, well, Bollywood producers would take the easy way out. They would position themselves like Hollywood producers, which is also fairly fashionable now, and would start calling themselves licensees instead of assignees. They would just get an ironclad license, an exclusive license, which gives them right to further sublicense, and they would probably put in a negative covenant saying that you cannot assign it without my consent, and the spirit and purpose of the amendment is entirely destroyed. There have been various discussions such as, well, they could assign it to the hair and the hair could assign it back to me. What we are definitely going to be looking at is creative contracts. We would be living in fool's paradise to think that producers are going to effectuate this and everyone is going to live very happily. Definitely there are loopholes which are present in the law which are very easily obvious to us and which have not been considered in the course of the Copyright Amendment. Now, what the Copyright Amendment has done is only consider the agreements which are in vogue, that is, namely assignment agreements, which are very peculiar to the Indian film industry. If they had taken the effort to consider international industry practices, they would have seen that traditionally producers are licensees. And they would have understood that what are the restrictions they have put on an assignment would also have to extend to a license if that is the intention to protect. Now, when I come to performance rights, the Standing Committee's observation is very clear. If a producer enjoys synchronization rights, authors, composers should enjoy performing rights, which is exceptionally broad, which can mean revenues from web, from advertising, from ringtones, and but what it does not consider, and this is something I was going through in the American auditing standards, is the cost to produce. When I look at the cost to produce a song, It includes the cost of musical talent, cost of technical talent, use of equipment, use of studio hire. And the accounting standard as per the American Institute of Certified Public Accountant provides that the producer is to bear a portion of the cost and recover a portion from the royalties accruing to the author. Cost to produce which are recoverable from the royalties payable to the author is treated as advance royalty. The Indian legislature does not even consider the commercial reality. So we have a producer who might be making a movie that's making him absolutely bankrupt. But he would still have to continue paying his composer, even though he cannot recover the cost to produce the song itself. Now, when you are interfering with the cardinal principle of privity of contract between two competent individuals, the reasons for it have to be justified and they have to be commercially relevant. Now, it also does not consider that the Act definitely does give scope for many societies, because if the Act said that if the language of the Act said the society, we would have obviously understood the legislative intent was we have one copyright society, you go there and everyone's life is simple. But in India things aren't always so simple. So the legislature went ahead and put a society. And the industry itself is fairly convoluted. The interests of Bollywood are not, what is the interest of the Tamil film industry, or what is the interest of the Bangla film industry. So therefore we definitely would see that there would be a movement to create their own societies, which in turn would again make the right of broadcasters very hard, because they would have to deal with different societies for different types of music who would have their different terms and conditions. Now, what is the effect on payment models to these authors and composers? The one-time payment model, well, it has become outdated, at least for the purpose of assignment, without going into the license conundrum. So the incentive upon what I feel, now this is entirely subjective, is that the incentive is on music composers to churn out commercially relevant music, because any producer is going to tell them, well, boss, I can't pay you, because get it from the royalties. So the chances of there being music which is fairly niche and expecting composers to survive off it becomes very hard. And it also creates a scenario which is very favorable for labels and producers, is that they get a composer to work pretty much for free. If it clicks, well and good, everyone takes home some revenue. If it doesn't, you have a composer who's worked almost for free. And it also, very disturbingly, which I'm sure will be reflected in the years to come, creates a conflict between a principal director of a movie and the music director of a movie. Because the principal director, the standing committee says, for the present purposes, is not a stakeholder in the movie. So the principal director is not going to be a direct beneficiary of the royalties of a movie, but the music composer is. So if the principal director feels that music need not be commercially relevant, you have someone who is a stakeholder, at least as per the law, who feels that it should be, and such conflict is entirely created by the law. And such rigid payment models in the Indian film industry probably will be circumvented. The industry survives on word of mouth. Lots of payments are unaccounted for, and that's a reality we are living with. We definitely would see a lot of artists completely forsaking agreements just to maintain good relationships with producers and directors and so forth. And then disturbingly, the focus then would become on how to break the law rather than how to implement the law when such rigidity is in place. Now, dealing with, just leaving all this aside for a minute, and since I've done a fair amount of John Doe cases, the Amendment Act amends Section 52(2)(c), and that allows a producer to approach a court seeking blocking of sites which are facilitating access to his movies. So we are definitely going to see a rise in litigation to protect online piracy. And well, I spent a lot of time. I spent a lot of time analyzing what is the difference in industry practice. What makes the difference between the American model and the Indian model? The American model, where authors obviously have huge amounts of royalties, where they have royalties coming onto the legal heirs. And the answer to me is very simple. The answer is unions. in Indian law, in India, you have the Federation of Western India Cine Employees. While going through whose illustrious history, I can only see them striking over hours for junior artists and employment of makeup artists who were registered with the union and so forth. Whereas when I look at the experience in UK or America, such as in UK, you have the musicians union and the writers guild, which provide standard contracts and minimum rates to engage the members. And of course, in America, you have these unions which take it one step further and which deal with contractual advice, which deal with recovery of unpaid fees, which deal with health and safety and so forth. And therefore, any distraction from what is the standard form prescribed by the union would require negotiation with the union itself. So what the industry lacked was basically proper unionization to protect their copyrights, and that unfortunately got reflected in a legislature which may or may not do it. We would have to see the contracts which come out, and we would have to see the reaction of the industry. But I still believe truly the only way in which authors and composers can achieve balance and parity in negotiating with authors and producers is to unionize, is to create standard form contracts, is to refuse to work otherwise. And we definitely would see a scenario that is what we see in the US and UK, and hopefully our artists would get the revenues they deserve. Thank you. Any questions?
Thank you, Arun. Why don't you, we can take the questions from here. Any questions?
My name is Nandini, and I'm a litigation lawyer from Calcutta. I believe the performers' rights are similar to the rights which have been amended by 1819, as in they are going to be adopted on a similar basis, and they are also going to be receiving royalties.
Yes.
I simply don't understand how is that going to work, because already these actors are being paid so much. I'm assuming that you're going to take in actors as well as singers when you're talking about performers' royalty.
No, I was dealing only with music composers.
No, I understand that. I'm just going a step further and saying that the Section 38A and all of those, they talk about performers' rights.
Yes.
And performers' rights include singers and also includes actors.
Yes.
And now actors, as we know, are the mainstays of Bollywood movies, and they're paying crazy amounts already.
Yes.
So how do we... I'm at a complete loss here to understand how will it work in the case of royalties for actors, because they are usually either paid if they are A, superstars on the profits of the film, or if they are the second level, then they're given a lump sum.
Yes.
But are we trying to say that with these new amendments, these actors are also entitled to royalties for any screening apart from theatrical this thing?
I'll just go through the provision if you can give me.
I don't know whether actors are included in...
Performers and actors, juggler, anybody.
Well, that's exactly the problem that most producers are citing with the Amendment Act, is that it creates too many stakeholders in the copyright, and identifying what is their rights and creating a viable revenue model is definitely, we'd only have to see how the industry is going to work, because the Indian film industry has always been a very unique animal, and to attempt to predict its reaction would be very foolhardy, to be honest. Sorry?
That's 18 now. The question of royalty table is set on the entire discussion comes only 18 applies.
Yes.
I understand it applies because it says that, but then I don't understand how it will work for actors and actresses, because they're already being paid crazy sums. Then are we at all suggesting that they have to be paid, or was that just something which got included because we wanted to include singers by default?
I don't think there was... At least when I had gone through the standing committee's report, there wasn't extensive discussion on Section 38A. The primary focus of the standing committee's report and of the various speeches and everything has extensively been on 18 and 19.
I understand that that's been the standing reports thing, but if you saw the debates,
So the definition of performance is when you make it live. So in a movie, you're not making it live. The shot doesn't happen live. So if it's a studio singer or an actor for a film, like Salman Khan acts in Exha Tiger, that's not a performance.
Yeah, I don't know whether. Whether actors.
Same applies to studio singers and all. It's only when Lata Mangeshkar sings the same song in a concert that it becomes a performance.
so when Salman Khan performs a scene out of his movie in all these reality shows, what do you call that?
Yeah, that can be a performance.
That'll, yeah.
And I think section 38A2 sort of addresses your question, because it says that.
Can I make an intervention?
Yes.
Yeah, sure.
Yeah.
Sure. Well, I think it's interesting to look at the whole things in its totality. Probably what we are stuck with is the current industry practice. What the amendment is looking forward is the transition that needs to take place in a changed context of if I use the word the industry has remained feudal, we are looking for industry to become real industry. The real industry is a situation where the different players in the industry will get the right type of recognition. The reaction seems to be to react to that type of a unique practice that the industry is following, and also find the way in which they move forward to understand how the industry behaves in a changed context. You were referring to the practices in US, and you are referring to the union and the collective bargaining that takes place to get the right balance on the sharing of revenue model. We are still stuck with superstars and the industry being led by the superstars, and then a one-time payment that makes. And we are ignorant about large number of performers underpaid or not paid in many occasions. So it is the industrial transformation that one is looking forward, how 20 years down the line, the Indian industry will behave in a changed, international context of globalization. Now, one can read definition. For example, if the word performer is read by saying live, then you need to ask the question, what is left out for a performer? Now, what performance is fixed and what performance is unfixed? And you have a right on the live performance. The performer's right globally is looking at fixed and unfixed. And it is your right to fix a performance that makes the performer's right. Well, you can undo it by a literal reading of it. And what is left out on section 38A? Well, it looks at from the perspective in which you are looking at it. If an industry lawyer appearing for a film industry, then you see it from that glass. If you are appearing for a performer, then you do it from that glass. If you are looking from a broadcaster, you are looking at it from that glass.
Absolutely.
Well, what we need to do is to look at the totality and then ask the question how the industry coexists in a context where there are multiple right holders inside. This is not new to global industrial practice. We look at the American industry and ask the question whether the performers and they get a right, they get a royalty. You look at the European industry and ask the question whether the performers get recognized and they get royalty. Because of certain strong industrial practices, we close our eyes and look at amendments from the perspective in which we are asked to look at it. Thank you.
If I'll just very quickly answer your question. See, section 38A2 says that if a performer does not have any, he cannot object to his use of his performance in the film by a producer. So that difficulty is eliminated. So, but then I think the royalties will arise when his performance is used for a purpose apart from it being used as part of a feature film, for example, as a product promotion or anything. Then the performer would be entitled to a royalty. That's my understanding of section 38.
Okay.
Performers is everyone.
Okay. Yeah, please.
Hi, Arun. My name is Anjum Rajabali. I am a scriptwriter and I am here representing the Film Writers Association. Unfortunately, there are just too many things which you said which I would like to actually respond to based on the ground reality, historical and current. But that's not the format of a question. So I'm going to restrict myself to your basic thrust, which was that why is it that this intervention and this amendment of this kind was necessary in India and not elsewhere? I mean, why weren't foreign laws considered, for example? I mean, there is no Prevention of Dowry Act in the US, for example. Okay, there also marriages do take place. There are men, women, and households and families, but there is no Prevention of Dowry Act. There's no Prevention of Sati Act there. It also depends upon the prevailing practice here, about the prevailing norm, the kind of disempowerment which was just not going away. The weak union, yes, of course, you're right about that. There are historical reasons for that. There are reasons why this film industry has not been an industry. They call themselves an industry, but they've never functioned like an industry, actually speaking, even now. An industry means that there are certain norms for good business practices, there is a propensity towards self-regulation, there is negotiation between the unions and the employers. There is no such tradition here, which is why the Federation of Western India Cine Employees, perhaps just all they could do was, as you said, talk about additional hours.
They didn't even make a... I'm sorry.
Hear me out.
It was shocking. They didn't even make a representation in the starting committee.
Oh, they did. I did. It's just that they never called me. Okay, we sent a huge, chitta, a dossier, repeatedly to that J. Sundrial. He was supposed to be coordinating that.
It's unfortunately not reflected.
Exactly. No, it is reflected because this thing which you're talking about outside of a theatre, that was my sentence. Okay, it wasn't there in the earlier thing. Plus, we had to, on an emergency basis, seek a meeting with Mr. Sibbil on the 24th of November 2009 when the final draft was to be out and put in Parliament on the 22nd of December. Okay, we came to know about it very late because the whole process was not publicized. There was perhaps no transparency that the MHRD allowed. So we came to know through an Indian Express report which came out, just one casual report, and which is why we rushed, the Film Writers Association rushed and made a representation. And unfortunately, there is a skew there because what happened is that they had already set down certain very sharply defined norms for lyricists and music composers because the whole effort and the whole focus seemed to be on that, like it is, for example, in this conference. Every time that there is even a discussion in public is conceived of for the implications of the amendment of the film industry or the entertainment sector at large, I don't think writers are taken into account at all. Whereas the majority of the people who are actually affected by this are screenwriters in film and as well as in television. It's not even a topic for discussion here. Okay, so I'm saying that you need to also understand that what were the historical reasons why there was a complete state of inequity in the whole contractual culture. If you see the contracts, which were the norm actually, it was horrifying, and it was very difficult actually to resolve that from union to union.
Yeah.
It took me 3.5 years to bring the producers to the table. So it was that state. So I'm saying, yes, of course, this has also given a boost to the union effort. So what we're doing right now is the Music Composers Association of India as well as the Film Writers Association, which includes the lyricists, which what you're referring to as authors, that we're looking at the implications of the amendment in the context of a minimum basic contract, which will be part of the negotiation between the union and the film producers and channels and studios. So it is being looked at it like that.
Right.
And we are aware of this. We are members of the International Affiliation of Writers Guilds. So I understand what you're talking about, but we've done that research. So it's in that context that this statutory intervention, which perhaps in some respects is considered draconian by producers, became imperative, not just desirable.
Yeah.
So I think it's important that we look at it in that context and then discuss why it was essential.
Thank you. No, absolutely. This session has helped to bring various stakeholders' points of view on the table with regard to a legislation, and that's because this copyright is one of the legislations which touches everybody's life, even though we are not always aware that it's touching our lives. Even when we read a book, it does touch our life. And so thank you very much, Prashant. Thank you, Arun. Thank you to all the organizers. Thank you for the SOS call, Shamnath. I would have missed out on this wonderful presentation and the discussions. And hope to be back. Thank you very much. Thank you.